Hello, everyone. I am AZ Hubbard, your host of SAVEDnews TV, and I thank you so much for inviting us into your homes. Well, today we have an update on the TD Jakes versus Duane Youngblood case. The judge has made his determination on the motion to expedite. And ladies and gentlemen, you know we do not have a dog in this fight. We report the news, we report the case, and we read the cases, and we also discuss. So it is very important to remember we don't have a position on this. But as we stated in a previous video, that when Youngblood filed pro se, it was a bad idea and that he needed legal counsel. And so he has gotten legal counsel. We discussed that in a previous video. And if you want to go back and watch that, you can go to our playlist. I made a playlist on TD Jakes versus Duane Youngblood. So you can watch all the previous videos to get up to date. So anyway, we got lawyer against lawyers fighting now. So we have a legal battle at hand and the judge has ruled. So let's get into this right now. All righty. In the United States District Court for the Western District of Pennsylvania, Thomas Dexter Jakes, plaintiff, versus Duane Youngblood, defendant. In the civil action, the Honorable William S. Stickman IV has made a ruling. So he's made a memorandum order. This action was initiated in November 2024. Plaintiff Thomas Dexter Jakes brought claims of libel, count one, against defendant Duane Youngblood, and civil conspiracy, count two, against Youngblood and 10 John Doe's defendants. Jakes alleges that Youngblood told a patently false story of Jakes grooming and attempting to assault Youngblood during Larry Reed Live online video podcast interviews on October 28th, 2023 and November 3rd, 2023. So we're going to stop right here. That is a typographical error. Those dates was 2024. So, anyway, then by letter dated November 15th, 2024, a lawyer purporting to represent Youngblood demanded that Jakes pay Youngblood $6 million in order to, quote unquote, resolve this matter quickly and privately. Otherwise, Youngblood would bring a lawsuit against Jakes for SA and harassment. Pending before the court is Jake's motion to expedite discovery. Jakes claims he knows the identity of the podcaster, Larry Reed, and the podcast company, Larry Reed Live LLC, but that he require, quote unquote, but he requires expedited discovery to further develop the factual matter to properly and appropriately support naming the podcaster and the podcaster's company as defendants. He seeks to begin discovery prior to Rule 26F conference and issue two third party subpoenas for documents in an effort to verify and identify the John Doe defendants. Briefing is complete on the motion, and the following reasons it will be denied. Okay. Well, everybody, we starting first that the judge has off the top said motion to expedite denied. So that was quick, fast, and in a hurry. Okay. And he goes on to explain under the federal rules of civil procedure, a party may not seek discovery from any source before the parties have conferred as required by Rule 26. F. The rule allowed for discovery prior to Rule 26F conference when authorized by court order. District courts have a broad discretion to manage the discovery process and may expedite or otherwise alter the time and sequence of discovery. In the matter of fine paper antitrust litigation, matters of the docket control and conduct of discovery are committed to the sound discretion of the district court. While a standard of assessing motions for early or expedited discovery has not been announced by the United States Courts of Appeal for the Third District Circuit, the prevailing approach in this circuit is to apply a quote unquote good cause or reasonable standard. List several cases right here. The good cause standard requires a district court to consider the totality of the circumstances to discern whether the need for expedite discovery in consideration of the administration of justice outweighs the prejudice of the responding party. The court holds that Jakes have failed to show good cause that exists for expedited discovery. It recognizes that Jakes seeks to uncover the identities of the Doe defendants in his complaint. So really what the judge is saying is, TD Jakes don't know these people and he's trying to find out who his does are, and that's not allowed. So this is what he quoted from the case. On information and belief, plaintiff alleges that defendant does 1 through 10 inclusive are other parties not yet identified who have acted in concert and agreement with Youngblood in order to commit defamation conduct against plaintiff and have committed acts of furtherance of such wrongdoing. The true names, whether corporate, individual, or otherwise, of those 1 through 10 inclusive are primarily not fully known to the plaintiff, which therefore sues said defendants by a fictitious name and will seek to amend the complaint to show their true names and capacities, which should have been ascertained. Written his conspiracy claim against the Doe defendants, Jakes explains that these defendants worked together to publish and broadcast the false claim that Jakes groomed him and S.A. Youngblood on a podcast reaching over 100K persons, knowing that making such false claims on a podcast that reaches such a broad audience of listeners would harm Jakes. The most he notes of the alleged conduct of the Doe defendants is that, quote unquote, co-conspirator number one falsely claimed in sum or substance during the podcast that Jakes had engaged in settlement discussions with Youngblood regarding his claims, end quote. In his brief in support of his motion to expedite discovery, Jakes states that he believes the podcaster Larry Reed had knowledge of Youngblood's plan to obtain money from plaintiff, and he claims on information and belief, plaintiff submits that there was a plan between and among defendants Youngblood and his co-conspirators, including the podcaster, to share in anticipated extortion payments once made. According to Jakes, without expedited discovery, he will be unreasonably delayed in amending the complaint, risk alternative conferences with the court once those parties are later added during discovery, and he will face potentially avoidable disjointed motions initially challenging the complaint, which in turn will likely disrupt the order flow of the case management of this case. No third party subpoena will issue. The bald and vague assertion that other individuals are part of a conspiracy to defame Jakes is simply not sufficient at this juncture to warrant expedited discovery. Okay, so Jake's team better step it up because the judge seems like he's not playing. He's like, look, expedited discovery is not going to help you at this time, and your claims is not enough for me to honor this expedited discovery. Okay, that's pretty much what the judge said. Okay, and that Jakes hasn't shown good cause as it goes on. Jakes has not shown good cause. The judge will not exercise its discretion to permit discovery to occur before Rule 26F conference. There is no immediate need to issue third-party subpoenas, especially the exceedingly broad ones Jakes seek. Okay, so this judge isn't playing. So Stickman seems like he's the type of no nonsense type of judge that's not taking any sides, that's saying, look, come correct or take it back to the house. Okay. You know this is broad. It is too broad, and there's no reason for us to speed up the process so you can name your co-defendants. Okay. The thing goes on to say he has failed to put forth viable evidence that destruction of evidence might occur. Without any concrete evidence of spoliation, the court will certainly not speculate that evidence was or will be destroyed. Further, the information before the court in such that Jakes has made no articulable showing that the discovery he seeks would actually lead to the identities of the Doe defendants. So, in other words, what the judge is saying is, you know, you all haven't presented enough evidence to say that this is going to help you even identify the Does. Okay. Woo. Notably, Jakes has already admitted that he knows the identity of the podcaster and the podcast company. Good cause does not exist to permit expedited discovery, and the court will not delve into Youngblood's substantive objections to the discovery Jakes seek. Okay, so in other words, Jakes, go back to the drawing board. If you want to file something and just add Larry Reed and Larry Reed live show, you better do it, because if not, the judge isn't playing. He is not going to allow you to get that information. Either you add them or you don't. You do it on your own, but you're not going to get information from the judge through an expedited motion so you can add the other ones. So that's pretty much what it was saying. Okay. Youngblood has not filed an answer or affirmative pleading to the court finds his attention should be focused on evaluating the merits of the case and not prematurely litigating discovery matters, particularly those seeking information from third parties. So the judge saying, listen, right now, Youngblood, since you sued him, he needs to be focused on the case at hand. He hasn't filed a motion in the affirmative, an answer, and him having to stop to do what you want for expedite the discovery. Nah, it's not even warranted at this time. It's not, especially since it's coming from third parties, the information that you want. The case goes on to say Youngblood has informed the court that he, quote unquote, fully anticipates filing a 12B6 motion to dismiss, a likely motion for sanctions, and if necessary, an answer and new matter to the complaint, along with any other appropriate requests for relief. According to Youngblood, Jakes is attempting to use the court as a means to stemming defendants' Amendment rights and to intimidate the third party's YouTube television show hosts from reporting legitimate claims of assault and misconduct perpetrated by the plaintiffs and other members of the clergy. So that's, i.e., that's what would be the, when Youngblood stated earlier that he wanted to do an anti-SLAPP motion to dismiss, that's what the judge is talking about. So again, go back to the previous videos to get caught up if you're not caught up before. Okay, it goes on to say, hence, at this juncture, it is unknown if this case will proceed to the discovery stage. Whoa, wait a minute. Oh, he said, what the judge is saying, listen, Jakes, I'm not going to give you expedited discovery because, and amongst the various reasons, there are motions that Youngblood stated that he planned on filing, including an anti-SLAPP. And I don't know how I'm going to rule on that request. I might rule in Youngblood's favor to dismiss this whole case. So there's no reason to do an expedited discovery because there might not be a case because I might end up dismissing it because of the fact that there's an anti-SLAPP motion and I rule in his favor. So, in other words, the judge is telling TD Jakes, look, you're getting ahead of yourself, way ahead of yourself. Okay. And then the judge goes on to say, it says discovery stage. And we go down here to, if you see the footnote 1, let's go to footnote 1. The court has the discretion to stay discovery pending resolution of dispositive motions. Okay. And it goes on citing district courts acted within the discretion to stay motions while considering defendants' motions to dismiss. This is because delaying discovery until a district court has the opportunity to determine whether a plaintiff is pled the necessary facts to proceed with his claims may obviate the discovery process and assist the streamlining the discovery process and minimize the burden of the parties and the court. Okay, so like I said, what the judge is saying pretty much is, we don't even know there's going to be a case. He already said that he's going to file an anti-SLAPP motion. I might rule in his favor. There is no case, no need for discovery. The end. So hold your horses. We're not there yet, TD Jakes. That's pretty much what the judge is saying. The judge continues, Jakes has failed to answer to the court's satisfaction how his discovery outweighs the hardship Youngblood would suffer by litigating expedited discovery issues. Okay. Jakes, you need to pull your attorneys to the side and y'all need to huddle up and come back with some more details and to, because there seemed to be some lack of stuff that, you filed. I know you all were filing, which was good, but it seems like, since Youngblood has gotten an attorney versus trying to do this on his own, it seems that the courses has changed. And then this is a real fight in the court system. Okay, so also now he continues, and now this 15th day of January 2025, it is hereby ordered that the notice for the motion for expedited discovery is denied. This case will proceed in normal fashion, and discovery will not commence until after Rule 26F conference. The court will permit liberal amendment of pleadings pursuant to Federal Rule of Civil Procedure 15 upon the timely manner motion filed. Okay. So pretty much the judge has denied TD Jakes the option of doing this. What do you think? My recommendation would be, hey, TD Jakes, go back to the drawing board. That's what the judge is saying. Or, you're going to have to follow Rule 26F. We are not going to expedite anything. And so there's a legal battle now. The gloves are off. The gloves are off. Okay, everybody. So also filed in this case was for Tyrone Blackburn Esquire to be admitted into able to represent Youngblood in the state of Pennsylvania in the Western District of Pennsylvania. As you know that from previous videos that Blackburn is not licensed in Pennsylvania, so he would need to come underneath another law firm. We're not going to read all this. I will put this in the members only section. And so if you want to read this is just stating that he is requesting to be admitted and he has been admitted. So there you go. And to represent, Youngblood and the does in the case. So this is what this is. Again, I will put that in the members only section. So anyway, everybody, there's that. So you got a real legal battle going on. Things are moving right along now. So what are your thoughts on that? Again, make sure you like, share, and subscribe. We are going to put the information in the members only for this particular filing. Also, make sure you check out the playlist so that you can keep on top of everything that is going on and that has transpired. We appreciate you. As always, thank you so much for allowing us into your homes. You all have a very wonderful, blessed, and prosperous day. As this case updates and comes, we will be on it. Make sure you stay with us because we will be reading out these cases. We don't have a dog in the fight. And it is what it is. So tell me what you think down in the comments. Get on it. Talk about it. Talk about it. Talk about it. All right, everybody. Have a wonderful day. Bye.
I'm writing lines to lift his name. No need for fame. My spirit fed, his word is spread, saves the aim. Pen to paper, truths I scribe, a soulful vibe to glorify the Most High. Let's amplify. I am spreading the faith I hold so dear. For every tear he's ever near. Choirs rise on Sunday morn. His love we adorn. Each melody, a testimony, hearts reborn. In every verse, a whispered prayer beyond compare, to lift the hearts of those in dark despair. We testify with every note we sing. In harmony, let freedom's bell ring. Rejoice and lift your voice. Let the sound of praise deploy, marching to his